Good morning, everyone. Thank you for joining us today for our webinar, Recent Cases of Interest. Our presenters today are Ken Hill, our Associate Deputy Director, and Felicia McGinnis, Associate General Counsel. If you would like to download today's presentation to your desktop, go to the Handouts tab on the GoToWebinar control panel, and you can download it there. If you have questions throughout the presentation, our presenters today will not be taking questions throughout, but please type in your questions in the questions tab as you think of them. And during the breaks in the presentation, I will read off the questions to the presenters. And also, any board members who are attending the presentation live today will automatically receive their 3 credits. You do not need to do anything. Just check back into your account in about a week to make sure that your credits have been appropriately added to your account in Prosper. And that is it. I'm trying to think. If you have any issues with your audio or trouble downloading the presentation, shoot me an email. I'll be checking my email. And with that, I will hand it over to Ken Hill, who will be starting the presentation today. Thank you.
Thank you, Natasha. I appreciate that. All right, good morning, everyone. So Felicia and I are going to be presenting on recent cases of interest. These were cases that were decided in the last year. As most of you probably know, we are still in a pandemic. Many courts have been closed, no juries, virtual hearings. Because of all of that, there haven't been as many decisions as there normally are. But Felicia and I have gone through it, and we found about 20 and a half cases. 2 cases were consolidated that we're pretty happy with. Some of them are unusual, they're unique and you'll likely never see them, but hopefully you find them interesting. Other cases are things that are fairly common and are changes in the law that you might find beneficial as a board member. Okay, Felicia, if we could go to the next. Okay, here's a list of all the cases that we're going to be presenting on. One more thing that Natasha touched upon with the questions. If you do type a question to us, because I'm not going to be answering questions until I'm done with my 10 cases, it might be helpful if you put the name of the case in your question, just so I can go back to it with these. All right, thank you. All right, the first case I'd like to present on is POP v. the State Board of Retirement. This is a case that involves group classification. That can be found in Chapter 32 at Section 32G. The idea of having group classifications is that the more difficult or stressful job that someone has, the more they should have an accelerated benefit. 32G classifies, well, most of us are, most of us are Group 1, as you know. It's the catch-all. But then Group 2 is a rather long list of jobs and occupations that would fall into Group 2. Group 3 is public safety. Now, that brings us to Ms. Pop. Ms. Pop was a nurse at the Holyoke Soldiers Home. That's the place that unfortunately had a lot of trouble early on in the pandemic. But Ms. Pope retired prior to the pandemic. When she retired, she asked that her group classification be made Group 2. The State Retirement Board denied her request, and she appealed it to DALA. Now, Group 2 includes, I'm quoting here, employees whose regular and major duties require them to have the care, custody, instruction, or other supervision of parolees or persons who are mentally ill or mentally defective. Now, Ms. Pop worked in the hospice unit at the Soldiers Home. The hospice unit was reserved for terminally ill patients. These patients usually did not survive a year. They were deemed terminal in a year. Many of the patients that were placed into that unit, though, also had mental illness. They had PTSD or Alzheimer's or things like that. The State Retirement Board denied her request for Group 2, though, because the primary reason that those patients were in the hospice unit was because they were dying of something else. They weren't dying from the mental illness. So in her appeal, the Delaware magistrate stated that she had to show that her regular and major duties, more than 50% of her time, involved the care of mentally ill persons. Now, this is particularly fact specific, okay? Here, the evidence showed that the majority, more than 51% of the patients in her care suffered from mental illness. The fact that their primary diagnosis was not mental illness did not matter, and she met her burden. The State Retirement Board disagrees with that finding, however, and they have appealed it to CRAB, where it is pending right now. The next case I would like to present on is Knight versus the Mass Teachers Retirement System. This is a pension forfeiture case under Section 15. As most of you probably know, if your pension is deemed forfeited, you're only entitled to a return of your contributions made with no interest. That brings us to Mr. Knight. Mr. Knight was a longtime teacher with over 30 years of creditable service. In September of 2018, he was arraigned on charges of child abuse on several children that were his former students. Mr. Knight actively defended those charges. He applied for superannuation about 1 month after he was arraigned. The teachers' retirement system was aware of the charges pending against him. They have a concern, because it's happened to them before in many other boards. The concern being that if you refund or pay a benefit to someone who's forfeited, it's extremely difficult to recover any amounts in excess of what they contributed. So the teachers' retirement system instituted a policy. That policy was, whenever a member is involved in criminal proceedings, but prior to conviction, if they request a refund, they get only the contributions without interest pending the disposition of that case. If they request a superannuation, like Mr. Knight did, they get the benefit, but only up to the contributions made with no interest. So they told Mr. Knight they would pay his retirement benefit, but once he got to $187,000, they would stop payment on that. That would be about 3 years. Mr. Knight appealed. The Delaware magistrate looked at it and was sympathetic to the teachers' retirement system's plight and all other retirement systems, and noted the difficulty it would be to recoup anything, any contributions that they made that exceeded what he had contributed. But they noted that Section 15(4) specifically states that no member may receive a retirement allowance after a, quote, final conviction. So just because the criminal charges were pending, okay, they could not institute that policy. Okay. The teachers' retirement system seems to have acknowledged the statute and its specific language, and they did not appeal that. So this is a final decision. The next case is Mason versus Mass Teachers Retirement System. As most of you know, a future retirement benefit is considered a marital asset. As it is a marital asset, it can be divided in the divorce proceedings. The document that enunciates that division is called a domestic relations order, or a DRO. Okay, so basically what you can say is, when I retire, my ex-spouse gets such and such percentage of my retirement benefit. Well, Ms. Mason was married for 19 years. She and her husband entered into a divorce agreement. As part of that, they completed the DRO. The DRO said many things, but it also said that her ex-husband was only eligible if he, quote, has not married. And it also said, at the time of her retirement. Okay. Well, Ms. Mason continued to work after her divorce. Her ex-husband remarried. Several years later, he got a divorce from that second wife. After that, Ms. Mason retired. When she put in her retirement papers, she chose option B. The teacher's retirement system said that she could not do that because the DRO they had on file said that she had to name her husband as the option C, and because he was not married at the time that she was retired. She appealed that to DALA, and the magistrate agreed with the board. DALA found that it must be read in, those two phrases must be read in conjunction. So it has not married at the time of retirement, okay? Literally, that wasn't the case here. So he was still the option C applicant. She did not like that decision. She appealed it to CRAB, and that is the decision that just came out recently. CRAB determined that section 12(2)(c) states, to be eligible for an option C benefit, you must be a former spouse who has not remarried. Okay? The statute doesn't say anything about at the time of retirement. They found that the DRO can't go against the statute, okay? And because he had remarried, he was not eligible for the option C. So they said that she could apply for option B. Teachers' retirement system appears to have disagreed with that, and they have appealed it to the Superior Court, where it is now pending. The next case is Kern v. Dedham Retirement Board. This is a rather straightforward case, but I'll explain why I'm presenting on it. As most of you know, you're only eligible to purchase military service time if you apply for it within 180 days of being notified that you can purchase it. Here, Mr. Kern worked for a long time. He went to purchase his military service time and was told he could not. He argued that he had no recollection or knowledge that he had been notified of it. The retirement board had no record of the actual notice, but they did have a record that it had sent him notice back in 2004. The DALA magistrate found that it's not necessary for the board to prove that he actually received the notice, only that notice was sent. So he was denied the ability to purchase that time. Now, the reason I bring this up is because for the last several years, PERAC has filed legislation seeking to change this. The bill filed would allow anyone up to 1 year after vesting in which to make the service purchase. So essentially, someone would have 11 years. It also allows anyone who is deemed ineligible prior to the legislation a 1 year period to apply for the buyback. So if this legislation passes, Mr. Kern would have a year to apply. The last I checked, this legislation was at House Bill 11, and it was reported favorably by the Joint Committee on Public Service, and it is now in the House Ways and Means Committee. The next case I'll present on is Combra v. State Board of Retirement. This is a very sad case. But before I begin it, I just want to, it's well settled in Massachusetts law that to be considered in the performance of one's duty and be eligible for a Section 7 or a Section 9 benefit, okay, you must be going from a work obligation to a work obligation, okay? So you're in the performance of your duties if you're going from a work obligation to a work obligation. You are deemed not in the performance of your duties if you're coming or going from a non-work obligation. So for instance, I'm in my office right now performing work. I get up, I walk to the bathroom. The bathroom is a non-work obligation. Okay? If I'm injured on the way there, I would not be eligible. Okay? Same thing with commuting to or from work. Okay? You're heading home, you're coming from home or you're heading home, you would not be eligible. Okay? By that as way as background, Ms. Combra. Ms. Combra worked for the Department of Mental Health. DMH has various facilities, They have monthly meetings for employees like herself, and they're at away locations. So she had one of those meetings and she had to drive to it, which she did. And she attended that meeting. And then around noontime, all the attendees at that meeting decided it was lunchtime and they went to lunch. The Dala magistrate who heard this case heard evidence from her colleagues that were there. And they testified that at that lunch, they ate, and then they discussed work. And then they went out into the parking lot and they discussed work. And then she got in her car and she drove to the office where she did work. But unfortunately, she did not make it there. She was involved in a car accident and she passed away. Her husband filed for accidental death benefits under Section 9. The magistrate found that after she ate lunch and discussed work business, she was in the performance of her duties. The magistrate further found that while she was in the parking lot talking about work with her colleagues, she was in the performance of duty and was at a work obligation. Okay, so the magistrate found she was at a work obligation and she was going to a work obligation, and therefore she was in the performance of her duties. As I said, the law, it's a harsh law, but it's been well settled in similar cases that if you're at lunch and then going to a work obligation, you're not in the performance of your duties. So this matter has been appealed to CRAB, and that's where it's pending right now. Like I said, very sad case though. The next case is Lombardini versus the State Board of Retirement. Ms. Lombardini was a member of the parole board, okay, and she resigned prior to the expiration of her term. However, she then filed a civil lawsuit against her employer, saying that she was forced to resign. The parties agreed to settle for a lump sum of $200,000. The settlement agreement made no mention of what that money represented. Okay. Ms. Lombardini then went to the retirement board and said she wanted to buy back service time for the remainder of her term. And she pointed to the settlement agreement, and the State Board of Retirement said, we don't know what that payment was for. If the settlement agreement had said, this figure represents the money I would have earned for the remainder of my term, then they would have allowed the buyback. PERAC has long time agreed with the board on that. If there is a settlement agreement, the parties must state whether any of the money represents back pay of some sort. That's the only way that a party can purchase service time. The magistrate agreed, and the magistrate said, said what I just said, but it also said the retirement board was not consulted on this, and they were not even a party to the settlement agreement, so they can't be bound by it. Magistrate even went so far to say that even if the settlement agreement had contained a statement that this figure represents back pay, that the retirement board would not be bound by because they weren't a party. I think the State Board of Retirement would disagree with that, and PERAC would disagree with that. So if you are involved in a settlement agreement of some sort, make sure it states what the payments are for. And if it's for back pay, then state that and state the dates. Okay, that'll ensure that they can do a buyback. The next case is Carruthers versus the State Board of Retirement. Mr. Carruthers was a professor at UMass and UMass Medical School for a long time, since 1982. He was a salaried and tenured professor. As that, he was entitled to certain guarantees, like he had job security, tenure, academic freedom, but he did have to publish and he had to fundraise. Well, in 2016, he entered into a separation agreement with his employer. His title changed from academically salaried professor with tenure to professionally salaried non-tenured professor. Okay, so he gave up his guaranteed employment, but he wasn't required to publish or fundraise anymore. His salary was increased, as a matter of fact, from $270,000 to $300,000, let's say. The separation agreement also provided that he agreed to retire in February of 2018, which he did. While calculating his retirement benefit, the state board determined that he tripped one of the anti-spiking provisions of 52F because his salary increased by more than 10% between two of those years. He appealed, and he argued that he had a bona fide change in position, and thus he met one of the exceptions to the anti-spiking legislation. The state board disagreed. He appealed to Dalla. Well, Dalla agreed with Mr. Corrupt, Dalla agreed with him. The state board appealed to Crabb. Crabb agreed with Dalla that there was indeed a bona fide change in his position and that the anti-spiking provision would not apply. However, Crabb found that the payments made to him pursuant to the separation agreement were payments made as a result of the employer having knowledge of his retirement and were therefore specifically excluded from the definition of regular compensation. So that roughly $30,000 increase was made knowing that he was going to retire. And that is one of the exceptions. It was made in contemplation of his retirement, which is an exception to wages. And so, I mean, in a way, if he had not argued about the anti-spiking, he would have ended up with more money. So that $30,000, he didn't have to pay any contributions on it, but it was not used in calculating his retirement benefit. And that is a final decision. The next case is the Mass Teachers Retirement System versus the Stoneham Retirement System. Okay, and this is a 3/8C reimbursement case. There was a member of the Stoneham Retirement System back in the 70s. Okay, she earned about 18 months of creditable service. In 1976, she became a member of the Teachers Retirement System, and Stoneham transferred her account, which was under $350. She worked for teachers for a long time, and then she retired in 2009. 8 years later, in 2017, Teachers Retirement System sought reimbursement from the Stoneham Retirement System for a portion of the retirement benefit payments that they had made to her. A 3/8C calculation was done. A figure PERAC came up with a figure. Stoneham agreed to repay 6 years of that, okay? Teachers wanted the full 8 years that they had paid out the benefit. The reason Stoneham said that they would only pay for 6 is that Section 3/8C says that the party seeking the reimbursement may maintain an action of contract to recover that amount. Now, in Massachusetts law, a contract action has a statute of limitations of 6 years. Okay, so if you have a contract with, let's say, a roofer to do work on your home, and you agree to pay him, but you don't pay him, he has 6 years to bring an action to recover that. If it's in excess of 6 years, it can get thrown out because of the statute of limitations. Well, the state board disagreed with the Stoneham Retirement Board and said, you owe us for all 8. This is not a contract action. And they brought an appeal through Dalla pursuant to 16.4. Dalla found that the statute does not require the party seeking reimbursement to bring a contract action. The statute says that they may bring a contract action. It's also proper pursuant to 16.4 for them to bring an administrative action through Dalla. So basically here, they found that because teachers took the action that they did through 16.4, that the 6-year statute of limitations did not apply to them, and they were entitled to the full 8 years of reimbursement. The next case is Hartnett versus Boston Retirement System and PERAC. This is another anti-spiking case. Now, Ms. Hartnett worked for the state and was a member of the state retirement board from roughly until 1990. Toward the end of her service, she earned approximately $34,000 a year. 12 years later, in July of 2002, she began working for Boston, and she joined the Boston Retirement System. She worked for Boston until April of 2006, and at her departure, she was earning approximately $100,000, and she'd accrued 3 years and 8 months of creditable service. Several years later, in 2016, she applied for superannuation. The anti-spiking legislation says that if in the 5 years of creditable service immediately preceding retirement, the difference in the annual rate of regular comp between any 2 consecutive years exceeds 100%, then you have to base the retirement calculation on 5-year average rather than 3-year average. Well, in looking at this, the Boston Retirement System said, okay, well, she only has 3 years and 8 months with us, okay, but we need to look at 5 years. So they looked back at 1989 and 1990, okay. They saw that there was a more than 100% difference between her salary in 1990 and her salary in 2002, and that she tripped the anti-spiking legislation and that they had to look at the full 5 years, do a 5-year average rather than 3-year average. This would seriously reduce her retirement benefit. She appealed and argued that consecutive can't apply here because the years 1990 and 2002 are not consecutive, okay? So you can't look at the 5. The Dollar Magistrate and now recently Crabb found that the anti-spiking legislation has to apply that way. That's certainly the legislative intent. Otherwise, I mean, the anti-spiking legislation was drafted for someone like her, not saying she had impure motives or anything like that, but it was drafted for someone who just jumps in at the end and tries to artificially inflate their salary. So both Dollar and Crabb have agreed that you have to look at the 5 years, even if there is a break in the service. Now, Ms. Hartnett has disagreed with that, and she has filed an appeal to the Superior Court, where it is now pending. One more thing, she also argued that it should not apply to her. Sorry about that, Felicia. Felicia's in charge of the slides. She also argued that it did not apply to her because she stopped working prior to the anti-spiking legislation being filed. The courts both said that that did not matter in this situation because she had not retired for superannuation until after passage of the anti-spiking legislation. The next case I'd like to present on is Morales versus the Lawrence Retirement Board and PERAC. This case has been going on for a long time, as you can probably see by the date 13, meaning it started in 2013. Well, the history of it is this. Mr. Morales was a police officer for the Lawrence Police Department. In 2002, he slipped and fell while entering the police station. He injured his shoulder. In the injury report, he noted that the incident occurred at 8:50 a.m. and that his shift was 9 a.m. to 5 p.m. To the question, what duties were you performing at the time? He wrote, quote, report for work for regular tour of duty. Now, as I said before, Mass law has been consistent that you are not in the performance of your duties when traveling from a non-work obligation to a work obligation. Therefore, if you're not in the performance of your duties, you would not be eligible for accidental disability. Well, Mr. Morales worked for another 10 years. And then in 2012, he applied for accidental disability retirement based on that shoulder injury. At the board hearing, he testified that his shift had actually started at 8 o'clock and that he mistakenly wrote 9 to 5 because he sometimes worked that shift. It started at 8 o'clock, he said, and that prior to the injury occurring, he had been out interviewing the father of a murder suspect. So he said he was performing his duties. He was interviewing a witness. The board believed his testimony and they approved his accidental disability retirement. PERAC remanded it, however. The objective evidence that was contemporary at the time of the accident indicated that he had not begun working yet. Mr. Morales appealed to DALA, and he and some of his fellow officers gave testimony that he had been interviewing a witness. The magistrate found his testimony credible and ordered that he be granted ADR. However, during that testimony, he also stated that he was unsure whether he had interviewed that subject on the morning in question. He also said it was possible that he might have been backing up another police officer at a traffic accident that morning. He wasn't really certain in his testimony. But despite those inconsistencies, DALA ordered that he be granted ADR. Well, PERAC appealed to CRAB. CRAB found that his testimony, well, at CRAB, I'm sure most of you know, CRAB does not hear testimony. CRAB just looks at the record, which included the transcript from the hearing at DALA. So CRAB held, though, that his testimony was not credible and that he had not proved that he was in the performance of his duties. Mr. Morales appealed that to the Superior Court. The Superior Court held that CRAB must give, quote, substantial deference to DALA's findings. DALA is the one that heard the testimony, and they're best able to determine the credibility of the witness. And it was remanded back to CRAB with that instruction. Well, that brings us to the recent decision last month. CRAB acknowledged that it owed deference to DALA, and it said, despite that deference, Mr. Morales' testimony showed that he did not know with certainty that he had interviewed a witness that morning, and that his testimony was limited and conflicting and not credible, especially compared with the injury report that was filed contemporaneously with the injury. CRAB found that he had failed to meet his burden of proving he was in the performance of his duties. Now, Mr. Morales has until December 18th, which is just in a few days, to file his appeal with CRAB. File an appeal to Superior Court. I'm not sure if he has done that, but we'll try to keep you posted on that. And that concludes my presentation. I don't know if there are any questions that have been entered, but if there are, I'll do my best to try to answer them.
Great. We have a couple of questions. I'll read them off to you. The first one, for the Knight case, can General Law Chapter 268A apply to this case?
I'm not sure what General Law 268A is, as I sit here right now. If that person who entered that question could just shoot me an email, then I'd be happy to look into it and get right back to you. I'm sorry, as I sit here right now, I'm just not sure exactly how it would apply.
Okay, and the next question for Kern. What if retirement boards don't send the notice and member transfers? Who owns the liability of military service, or what board owns the 180-day notice, first or second board?
I think that in the past, we have said that the second board, we want to give veterans as much of a chance as we can for them to purchase that service. So I believe in the past, we have said that it is the second board.
And Ken, if you can just spell out the acronyms for DALA and CRAB for those who are unfamiliar with those terms.
Sorry about that. We deal with them a lot, so it's just so much easier. DALA is the Division of Administrative Law Appeals, and they hold the first hearing and issue a decision. If someone does not like that decision, they can then appeal it to the Contributory Retirement Appeal Board. I think you can probably see why we prefer to saying DALA and CRAB.
Everyone, once they learn it, they'll never say the entire thing.
Never say it again, yeah.
And the final question that I have, unless someone adds another one, is for Mason. Do you need proof of no remarriage for a former spouse to get a C benefit once the member has died?
I don't think you need proof of no marriage. If the member who passed away, if their family wants to look into it and see whether or not the ex-spouse had remarried and was ineligible, I guess they could do that. But you don't need proof that they haven't remarried.
Okay, that was the final question for this section.
Okay, great. Thank you all. I'll hop back on at the end of Felicia's presentation, and Felicia will now take over.
Good morning, everyone. As Ken mentioned, my name is Felicia McGinnis. I'm the newest Associate General Counsel here at PERAC. I started during the pandemic, so I likely have not met the majority of you guys who are on the call. So hopefully this coming year, we'll be able to do some in-person trainings and some conferences, and I can meet you all then. So the first case that I will be discussing is Haltmeyer versus MTRS, so the Massachusetts Teachers Retirement System. So this specifically deals with the purchase of elected official service time and the 90-day requirement. So in this instance, Ms. Haltmeyer attempted to purchase some prior elected service from 2001 to 2002 when she served as a selectman with the town of North Andover. She initiated this purchase with MTRS, and the Teachers Retirement System informed her that the Essex Regional Retirement Board had denied liability because she had never become a member or paid contributions. She appealed this decision to DALA, and they ultimately dismissed the case for failure to state a claim on which relief may be granted. So DALA found that Ms. Haltmeyer never elected to become a member within the 90 days of assuming office, and therefore she could not complete the service purchase under Section 32A VI. Ms. Haltmeyer had argued that if she would have been told that she needed to elect membership, she would have done so, but no one had ever mentioned it to her. But DALA affirmed the longstanding position in Good v. Weymouth Retirement Board and Norfolk Retirement Board that there is no requirement that a retirement board notify elected officials of the right to elect membership within the 90 days. So she does not need, the members do not need to be explicitly told of their right to membership. Recently, PERAC has put out some opinion letters and memos regarding the ability for elected officials to buy back time. And while it is not a requirement, we do highly recommend retirement boards notify newly elected officials of the right to membership. We have actually received some forms from a board that they created for elected officials to complete. They have to affirmatively check yes, they want to do membership, or no, that they do not want to obtain membership. So I think that is a good precedent to start, that the notifying of the members is really helpful, because sometimes they're not sure of what the rules are under Chapter 32. The next one I'll be discussing is Curley versus Stoneham Retirement Board. So this case deals with Section 94B accidental death benefits in relation to the cancer presumption. So under there, in order to be granted the cancer presumption for the accidental death benefits, they have to prove that the cancer should or would have been discovered during the 5-year period following a member's last day of work. So here, Mr. Curley was a former firefighter, and he retired for superannuation in December of 2002. He passed away in February of 2010 from end-stage pancreatic cancer, which was first diagnosed in January of 2010. His wife applied for the accidental death benefits, and the Stoneham Retirement Board had denied the application. They relied on a single medical panel physician review that determined that the cancer should not have been discovered within the 5 years of his last date of active service, which would have been December of 2007. So 3 years prior to when he was officially diagnosed in January 2010. Mrs. Curley appealed this decision, and at the DALA hearing, she testified, as well as two family friends, that during the time period from 2005 to 2007, Mr. Curley had experienced some specific symptoms such as cold intolerance, agitation, bloating, weight loss, kidney stones, distinct body odor, some mental health conditions, and they provided medical records to support this testimony. They also provided two opinions from board certified physicians and then a deposition from an oncologist who said that pancreatic cancer actually began 10 to 15 years prior to the diagnosis, and that the symptoms that Mr. Curley exhibited from 2005 to 2007 that was corroborated by the testimony and the medical records were actually consistent with developing pancreatic cancer. So DALA, the board in turn supplied another opinion from an oncologist who found that those symptoms testified to were really non-specific and that the pancreatic cancer could not have been discovered as early as 2007, which was the cutoff of the 5 years after he had his last day of work. DALA ultimately concluded that Ms. Curley was entitled to the Section 94B accidental death benefits, as the pancreatic cancer should have been discovered within 5 years of retirement. DALA found that the family and friend testimony was credible because it was consistent with supporting medical records, and also the two medical opinions and deposition testimony from oncologists who specialized in stem cell research and the diagnosis of cancer. The magistrate ultimately didn't give any weight to the expert opinions provided by the Stoneham Retirement Board. The DALA magistrate noted, the one expert cited to certain journal articles that actually dispelled his ultimate conclusion. So he found that there was no weight to be given to any of that testimony or opinion. DALA also determined that Section 94B does not require active cancer, just that there be a condition of cancer. So the early stages of just symptoms with no mass would suffice to meet the requirement. This is a final decision, and no appeal has been filed by either party. Now, this is the half case that Ken was talking about. It was combined. It's Willett and Houston v. Somerville Retirement Board and PERAC. Now, this also has to do with the anti-spiking rule of Section 5, specifically the exception to that rule for salary amounts that are specified by law. In 2016 and 2017, the Somerville Board of Aldermen created two local ordinances that raised the salaries of certain non-union municipal employees as a result of an advisory board report that said it needed to be done in order to attract more talent to the city. So based on the two ordinances, Mr. Willett and Ms. Houston received salary increases during the years 2016 2019 that exceeded 10%. When the two members ultimately applied for retirement, those years were included in their computations, and that triggered the anti-spiking regulations of Section 5. The Somerville Retirement Board then adjusted their retirement allowances downward to account for the spiking based on an opinion letter that PERAC had previously sent to the Marlborough Retirement Board. Now, in that opinion letter, we concluded that the salary amounts specified by a municipal or local ordinance were not salary amounts specified by law and did not meet an exception to Section 5. We found that the term law only included state or federal, general, or special laws, as Chapter 4, Section 7 of the general laws defined ordinance as a bylaw, and therefore it was not a law. Mr. Willett and Ms. Houston appealed to DALA, and DALA determined that based off of the Black's Law Dictionary and the use of the term bylaw, law, ordinance in Supreme Court decisions, law included state and federal laws, administrative regulations, bylaws, and ordinances. So DALA concluded that a local ordinance is a law, and any salary increase done by a municipal ordinance would be an exception to the anti-spiking rule. Immediately after the decision was issued, I think it was 2 days after the decision was issued, CRAB pulled the case on their own accord for review. So it is currently pending at CRAB awaiting a decision. Next case is the Reed versus Essex Retirement Board and PERAC. So this has to do with Group 4 members and their ability to apply for retirement while an active member in service under Section 5(1)M, regardless of the amount of service that they have. Here, Mr. Reed was a member of the Essex Retirement Board and was hired as a police chief for a 3-year term from January 2016 to January 2019. And these 3 years were his only years of Chapter 32 creditable service. In March of 2019, Mr. Reed applied for superannuation retirement, and the board contacted PERAC with questions on how to calculate his benefit since he had only worked for 3 years and they needed to average 5 years. During the review, we informed the board that Mr. Reed was actually not eligible for retirement under Section 5 because it only applies to members in service or members on authorized leaves of absence. Instead, Mr. Reed had a deferred retirement and was governed by Section 10(2)(b)(1)(2), which is the vesting statute, which is the vesting section of Chapter 32, and that requires 10 years of creditable service. Mr. Reed appealed, and DALA concluded that Group 4 members who do not retire while employed have deferred their application and are governed by Section 10. Those members must have 10 years of creditable service to be considered to have vested. If Mr. Reed had filed for retirement while he was still employed, say he filed in early January 2019, he would have been able to retire pursuant to Section 5(1)M, even though he only had 3 years of service because he was still an active member. Since he was not eligible for retirement, DALA concluded that instead he was entitled to a refund of his accumulated total deductions. This also is a final decision. No appeal was filed by Mr. Reed. The next case is Capurso v. State Board of Retirement and PERAC. Now, this is very similar to the Combra case that Ken had talked about earlier. It deals with the accidental disability retirement and being injured in the performance of duties. While Ken had mentioned that there's a longstanding precedent that traveling to and from home, and then leaving work to go home is not in the performance of your job duties because you're commuting from a non-work obligation to a work obligation. Here, Mr. Capurso worked as a special investigator for the Alcohol Beverages Control Commission. So in that job, he was assigned a work vehicle and did much of his work traveling to different locations and spent the majority of his time actually working out of his vehicle. His vehicle was fitted with a printer, a computer, a phone, as well as all of his equipment and paperwork. So in May 2013, he left his home at 6 a.m. to travel to a mandatory training and was subsequently involved in a car accident. He applied for accidental disability retirement, and the State Retirement Board approved the application. This was ultimately sent to PERAC and remanded 3 times because there was concern that he was not injured in the performance of his duties, that he was traveling from a location where he did not have a work obligation, his home, to one where he did. Following the 3rd remand, Mr. Capurso filed his appeal to DALA. So DALA concluded that Mr. Capurso was entitled to the accidental disability retirement benefits because he was in the performance of his duties while he was traveling to his mandatory training. They found that DALA found that Mr. Capurso's vehicle was his mobile office, and since he had testified that he checked his email and voicemail that morning before setting off, he was traveling from one workplace obligation, his mobile office, aka his car, to another, the mandatory training. They also found that he was in the performance of his duties while just driving because driving was a necessary part of his job, and his boss had testified that Mr. Capurso was considered to be on the clock at 6 a.m. when he set off from home. PERAC has appealed this decision to CRAB. We just filed our notice of objections last week. As the magistrate relied heavily on Combra v. State Retirement Board that Ken had discussed, which, as he noted, has been appealed, and so it's not a final decision. This case and Combra, as Ken mentioned, seem to shy away from the long-standing case law that traveling from home to work is not in the performance of one's duties. We are also concerned that the Dala magistrate determined that his car was his mobile office all the time, even though there was testimony taken that he would take his lunch breaks in the car. So even though the car was used for work, it did not automatically mean that the car became his office every time he entered it. So that is on appeal to CRAB, and we are awaiting that decision. We were awaiting Mr. Capurso's response to objections and then the decision of CRAB. This next one is Wachowski v. Massport. So this is a very fact-specific case about accidental disability based off of PTSD and whether the member's job duties actually caused his disabling conditions. So Mr. Wachowski began working at Massport in 1997. In 2000, he was promoted to the manager of Boston Logan Airport's Terminal C. Now on September 11, 2001, as we all know, terrorists hijacked 4 planes, and 2 of them had originated from Boston in Terminal B and Terminal C. For the flight that left Terminal C, the hijackers had boarded their flight between 7:23 and 7:28 a.m., with the plane leaving the gate just before 8 a.m. That day, Mr. Wachowski reported to work at 8:30 a.m., went to his office, and then drove to a mandatory HR meeting that was scheduled to start around 8:30 across from Terminal A. During that meeting, they all had learned that planes had struck the World Trade Center and 2 had originated from Boston. For several days afterward, Mr. Wachowski was working with the state and federal law enforcement, gathering information and inspecting Terminal C to make sure that it was safe for passengers and the airport to reopen. He also learned that he knew several individuals who had died on the planes and in the World Trade Center as a result of the terrorist attack. In October 2009, Mr. Wachowski eventually stopped working for Massport and applied for accidental disability retirement in June 2011 with the theory that he had undergone a hazard. He claimed disability from his PTSD, heart problems, chronic fatigue, and immune dysfunction syndrome. He reported that the hazard undergone was 9/11, which left with the plane leaving from his terminal. And he claimed that had he not been in attendance at the required meeting, he would have been on the floor scanning passengers and believed that he would have spotted the terrorists and stopped them. The medical panel that had examined him was a unanimous yes, 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 but the retirement board only awarded ordinary disability and denied his accidental. They found the disabling condition was actually his chronic fatigue syndrome. So Mr. Wachowski appealed the decision in September 2012, and in December 2012, DALA found that he was actually not entitled to accidental disability retirement because he applied 10 years later and had missed the 2-year window for alleging a hazard. He appealed to CRAB, the Superior Court, and the Appeals Court, all ruled that he was not eligible to apply for ADR. In September 2018, special legislation was actually passed that, notwithstanding the notice requirements of Section 7.1, he is eligible to seek accidental disability retirement. They didn't put in the legislation that he was to be granted it, just that he was allowed to apply. In November 2018, he filed a second application for accidental disability retirement, but on this application, he reported that he suffered both a personal injury and a hazard undergone. He again relied on 9/11 and his PTSD from the terrorist attack. He argued that he was continually exposed to the same environment by going to work in Terminal C every day after the attacks. DALA ultimately concluded that he was not eligible for accidental disability retirement because he did not prove his job duties caused his disabling conditions post 9/11. Prior to 9/11, Mr. Wachowski had treated for a slew of health problems consistently, such as fatigue, depression, anxiety, OCD, problems sleeping. And additionally, one of the physicians determined that the records of his heart disease didn't show that the heart disease was caused by his 9/11 experience, nor were the chronic fatigue and immune dysfunction syndrome that he had alleged. Dalla also found that his PTSD from 9/11 was not caused by his job duties because he was not even scheduled to be on the floor that day. And he was not scheduled to start working at the time that the hijackers went through security and boarded the plane. So Mr. Rakowski was officially scheduled to work that day at 8:30 a.m. And as I mentioned earlier, the hijackers' flight had already left the gate at 8 a.m. Additionally, scanning passengers and security was not even a job duty of his, so he would not have been on the floor that day anyway. Mr. Rakowski, there was also notes that when he retired in October 2009, he had retired because he suffered from toxic poisoning from eating fish, and that was the reason that he was not able to work. It was ultimately found that there was nothing in the record to suggest that the accidental disability was warranted. Dalla found that the unanimous yes medical panel was actually a negative for 5 of 6 of the alleged conditions. This was a 60-page decision, and the magistrate did a flow chart where he listed out every single condition that Mr. Rakowski alleged and each medical panelist and how they ruled on it. And 5 of the 6 conditions they found were not disabling. They did find him disabled, but they couldn't even agree which condition was a disabling condition. So the retirement board was actually right to reject a unanimous medical panel. Mr. Rakowski has appealed to CRAB, so we'll be awaiting that ultimate decision. The next case is Griffin v. State Board of Retirement. So this has to, again, do with accidental disability retirement. And this concerns the emotional disability filed by Ms. Griffin and whether or not the actions amounted to the intentional infliction of emotional distress. So as many of you may know, proving intentional infliction of emotional distress is very, very, very difficult. It is extreme and outrageous conduct and beyond all possible bounds of decency. So it's really hard to show that it's an extreme and outrageous conduct and it moves beyond anything that you would consider appropriate. The standard is very high to prove that. Here, Ms. Griffin was employed by the Department of Disability Services in 2006, and she was eventually promoted to a service coordinator supervisor in 2012. In January 2015, a new clinical director was hired who had a different management style than the other director. The new director was very confrontational and could become verbally aggressive if disagreed with. In February 2015, Ms. Griffin had a disagreement with this new director over authorizing her time off. She went to the director's supervisor and also sought clarification from her union. The new director became angry and warned her against insubordination and future consequences. In March of 2015, Ms. Griffin requested a transfer to a different regional office, but that was denied. In May 2015, the area director was informed that with the new director, there was problems with employee morale and office behavior. So another supervisor was hired in March of 2015 to work with this new director. That supervisor actually testified at the hearing that the director would belittle and complain about Ms. Griffin to her, and that she testified that the director had told her that she had planned to make Ms. Griffin fail her job by giving her difficult cases and overloading her with work. Several incidents happened in September and October 2015 where Ms. Griffin and the new director had verbal disagreements. She was shouted at and left meetings in panic attacks. She filed a grievance with her union rep in April 2016 because of the hostile work environment. And from June to September 2016, the union rep actually attempted to secure transfer to another office, but was unsuccessful. So Ms. Griffin returned to work in October of 2016. Days before she returned to work, her window office was assigned to a new contractor, her furniture was given away, and she was assigned to an inside office. She was also informed the day she returned that she would now be handling 3 times more cases than any of the other supervisors in the office. She subsequently had a panic attack and left. Because of these consistent panic attacks, she attempted to get ADA accommodations so that she would be able to leave for her panic attacks and multiple doctor's appointments. In retaliation of that, the director had threatened that she would terminate her over her inability to perform her job. Ultimately, her request for the accommodations was denied, but she was also not terminated. In March 2018, there was another reassignment of cases, with the majority being given to Ms. Griffin, and the assistant director who testified at the hearing was able to testify that the majority of the cases were given to Ms. Griffin because the director purposely did it to overload her again. Ultimately, because of all of this stress, she left work in May 2018. She originally applied for accidental disability retirement, and the state board would not process the application as they viewed that she was unable to prove any set of facts that would establish her eligibility for the benefit. It was more of a he said, she said. They processed her ordinary disability retirement application, but Ms. Griffin appealed the denial of the accidental processing. We convened the regional medical panel, and the 3 physicians actually went beyond the scope, and they opined the causation in the affirmative. So instead of a yes, yes decision, it was actually a yes, yes, yes. As a result of this, the retirement board did request a new panel to be convened and be re-examined. Ms. Griffin appealed that decision, but ultimately did end up attending a new panel and was awarded ordinary disability retirement. The member, since she had appealed the denial of processing her accidental disability retirement and had appealed the request for a new panel, DALA consolidated both of those cases. They found moot the requirement for her to attend a new panel because she did attend one eventually before the case was heard. But they did conclude that she was entitled to a medical panel for the accidental disability retirement application, and that the retirement board should have processed that application. DALA determined that Ms. Griffin had no treatment for mental health conditions prior to the arrival of this new director in 2015. Subsequent to the arrival, she was diagnosed with depression, anxiety, mood disorder, PTSD, and bipolar disorder. He found that Ms. Griffin had established a connection between the injury she described and the disability she sustained. She was able to have 2 credible witnesses testify to these events and interactions, and showed that she was not just perceiving something that wasn't there. She was able to show that this director specifically picked her out and was giving her more assignments and being more aggressive to her than other employees. The State Board of Retirement has appealed this decision to CRAB, so we are awaiting that decision. The next case involves another accidental disability retirement. A lot of the cases that came down from DALA and CRAB were all accidental disability retirements. And this one dealt on whether or not there was proof that her disability was caused by a workplace injury or a hazard undergone. So Ms. Boudreaux's worked as a librarian from 1991 to 2005 at the Edgerton Public Library, and then from 2005 to 2011 at the Oak Bluffs Public Library. So in May 2000, a new carpet was installed in the Edgerton Library. When she arrived at work, she immediately felt sick, could smell the new carpet, and had to spend several days at home, and the library was ultimately closed and aired out until the smell was gone. In 2005, the Oak Bluffs Library was being built. She smelled some of the new carpet again and actually specifically requested that linoleum be put in her office, which it was, but she still missed several days of work because of that smell. Again, in May 2010, she was affected by weed and feed that was used on the library grounds, so she had missed a couple days of work after that incident. Then from November 2010 until about October 2011, she had numerous sick days because of the smells in the library that had given her headaches, nausea, and dizziness. It was noted that during that time period, the HVAC system in the Oak Bluffs Public Library that she was working at leaked, and on repeated occasions there was sewage backup, and she could smell that, as well as the subsequent cleaning supplies of bleach and Clorox. In 2010, Ms. Boudris was officially diagnosed with what they called multiple chemical sensitivity. In 2011, she was actually reprimanded for scolding library staff and improperly interfering with maintenance work over the sewage. That grievance proceedings were initiated, and all parties entered into a separation agreement with her leaving work. In May 2013, she then applied for accidental disability retirement based off of her multiple chemical sensitivity. The medical panel was 2 doctors for yes, 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 and 1 said no. There was a heated discussion between the panelists about whether or not the multiple chemical sensitivity was actually a real diagnosis, but it was ultimately concluded that there was some evidence to show that it was a real condition. The board denied the accidental disability retirement application, and Ms. Boudris filed her appeal. She argued specifically that her exposure in 2011 to the wastewater and the bleach cleaning materials from the sewage spill had transformed her manageable pre-existing condition into an all-out debilitating condition. Dalla found that this argument was really not credible because she had exhibited sensitivity to the new carpets in 2000 and was out sick for several days. Then in 2010, she again suffered the symptoms with the weed and feed, and that's when she was officially diagnosed with the multiple chemical sensitivity. Dalla said that there was no hazard, as there was no real evidence that her multiple chemical sensitivity was actually caused by environmental factors in her workplace, rather than some just common etiology or a genetic condition. No appeal was filed by Ms. Boudris, so this is a final decision. The next case is Cavaretta versus the Malden Retirement Board. Again, this is another accidental disability retirement application, and this one specifically focuses on whether or not the medical panel lacked any facts or employed an erroneous standard in finding that the member was not eligible, there was no causation for his disability. So Mr. Cavaretta worked as a maintenance laborer at the Malden Housing Authority. In March of 2010, he was putting on a plow on a truck, and he pulled the pin out. When he did that, it snapped and struck him right in the side of the head. It knocked him back, gave him somewhat whiplash, and he reported immediate right-sided neck pain. That ultimately cleared up, and he returned to full duty. Then in December of 2014, he was fixing a sink and went to go down the stairs. At that time, he slipped on water, hit his head, slid down the steps, slammed into the wall, and knocked himself out. He reported right shoulder, elbow, neck, and arm pain. Now, after that incident, 2015 and 2016, he continued treatment for his neck and shoulder pain. He did physical therapy, different types of medication, and injections. Imaging also showed that he had significant cervical degenerative disc disease. In 2016, his orthopedic doctor reported that his predominant cause of his symptoms was his pre-existing cervical degenerative disc disease. As a result of these conditions, he applied for accidental disability retirement in November of 2016. His surgeon submitted a treating physician statement, unanimous yes, 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 for permanency causation. The regional medical panel was a yes, yes, no. They found that the incident was just an exacerbation rather than an aggravation of his pre-existing conditions. Based on the medical panel, the retirement board denied and Mr. Cavaretta appealed. Dalla ended up affirming the retirement board's denial of the application. They found that there was no erroneous standard employed and that the medical panel did not lack any facts. The panel reasonably found that the incident in 2014 was a temporary worsening of his conditions, not permanent. And now for this one, I picked this case because I felt really bad for him. He fell down a flight of the steps, hit his head so hard he concussed himself and knocked himself out. It was really incredible reading the medical records to see that it was only considered an exacerbation and not an aggravation. And so I felt very bad for him when I was reading this decision, but it is a final decision. No appeal was filed. This is the final case I'll be talking about, Kenworthy Lewis versus State Board of Retirement. This one has to do with Section 25C3 and the adjustment of a retirement allowance with the actuarial equivalent in interest. So for this case, in November 1975, Miss Kenworthy Lewis began working as an assistant district attorney for the Massachusetts Defenders Committee. She worked there until November of 1976, and she was paid out of an 03 account, which, if not all of you are familiar with that, that's a contractor account, and was not a member of the state retirement system. In December 1976, she became a permanent employee and a member of the Massachusetts state retirement system. In November 1981, Ms. Kenworthy Lewis resigned from her position, left public service, and she requested a return of her accumulated total deductions. Those funds were returned to her in January 1982. Then in April 1987, she began working for the Supreme Judicial Court and again became a member of the state retirement system. In 1988, she entered into an installment plan to buy back her prior service from when she was a member. So that was her December 1976 to November 1981 service. In 1993, she completed that buyback. Section 41S, created by Chapter 161 of the Acts of 2006, authorized eligible members in the service of the state retirement system to buy back up to 4 years of state contract service as creditable service. In August of 2008, the state retirement system adopted an amendment to that contract service buyback policy that said if the member terminates service and refunds money, then later returns to service, they are a new member and cannot purchase the contract service. So in August 2009, Ms. Lewis completed the contract service buyback form, requested to purchase her service from 1975 to 1976. The State Retirement Board informed her that she was ineligible to purchase that prior service because of the 2008 regulation. Ms. Lewis filed an appeal and then retired from the system in December of 2013. That case went to DALA, and they concluded that she was not entitled to purchase that service. She appealed to CRAB, and in August of 2015, CRAB reversed the decision and held that she was entitled to purchase that creditable service. So in December 2015, Ms. Lewis received a bill from the State Retirement Board for the amount required to purchase that service from 1975 to 1976. She had also requested for interest on her retirement benefit because if the service would have been properly granted when she initially retired in December of 2013, she would have been at 80%. But instead she retired at 76%. The State Retirement Board told her no because interest was only required when an error is corrected by a court per PERAC v. Essex County Retirement Board. So in March 2016, Ms. Lewis completed her buyback of that 1 year of contract service, and her retirement allowance was increased retroactively to December of 2013. She did appeal the State Retirement Board's denial to award her interest. Now, DALA concluded that Ms. Kenworthy Lewis was entitled to the retroactive adjustment of her retirement allowance to reflect the appropriate interest she was entitled to as a result of an error under Section 25C2. The State Retirement Board appealed this decision to CRAB, and CRAB upheld the DALA decision. They determined that Section 25C2 and PERAC do not require Retirement Board's error to be corrected by a court in order for the interest to be due. CRAB actually said that both PERAC and the State Retirement Board had policies that advanced the notion that appropriate interest should be paid where a benefit adjustment has been made as a result of an error under 25C2. CRAB found that here an error still existed in that the State Retirement Board was not paying the mandated actuarial equivalent to Ms. Lewis. So CRAB remanded the case back to the retirement board to calculate Ms. Lewis's retirement allowance to include the actuarial interest and make appropriate payments. This is a final decision. Neither party had appealed. So that concludes my cases. So Natasha, I can take some questions if anybody had any.
Yeah, we have several questions here. So the first one is for the Haltmeyer case. If an elected official joins a retirement system and then during one of his or her elections gets reelected by popular vote but decides not to continue membership, can that be done? In essence, if the elected official becomes a member, clicks alone, and then 6 years later gets reelected, can they decide not to contribute?
Okay, so I just want to confirm. So the question is, if the elected official is first elected and then they opt into membership and then they continue down that road, then when they get reelected at some point, they say, no, I no longer want to be a member.
Yes.
Okay. Ken, I'm not really
Can they
sure of
decide
this,
not
but
to
I know that
contribute?
once a member is always a member. So if they stop making, if they don't want to make any more retirement deductions, they need to defer their retirement or retire.
Yeah, I don't know if I've ever come across this question before. I agree with the once a member, but there was a break in service. So, you know what, very interesting question. I don't have the answer. You know, we may have.
So Judith just popped in quickly and she said, no, that's not allowed. Once
Not
you elect
allowed.
membership,
Okay.
you will be a member. You can't then change your mind
This
after
is
being
one of
reelected.
those let's trump the presenters.
Happy to have it.
Yeah.
All right, the next question. Why would notification of being able to join a retirement system in the town not be part of an HR packet when elected officials take office if theirs is a paid or stipend position?
So elected officials are not required to become a member of a retirement system. In the statute specifically, it says that they have the option to. That was changed. I don't remember when that language was changed, but it allowed elected officials, they have the option to either become a member or not become a member. So it's not automatically sent to them.
I think that PERAC has said that it would be best practice to include that information. And we would recommend that boards and human resource departments, but primarily the boards, what we deal with, include that information.
Okay, for Curly, can the Stoneham board hire their own doctors to dispute Curly?
So in Curly, they did get another opinion from a separate opiniologist to support their initial single physician medical panel review that had been done. So yes, so they did get a separate doctor to opine on the case and agree with their original decision that the pancreatic cancer could not have been discovered.
Next question. Just curious, with many active employees working from home due to the pandemic, has PERAC seen any injury/disability claims for members hurt while working at home?
So we have not received any specifically working from home other than one that we recently reviewed. But there has not been like an influx since the pandemic started of any work from home injuries yet.
Okay.
I think it's fair to say that we have expected it and we continue to expect it. But as Felicia said, we really haven't seen an influx of it yet.
Okay. Okay, next question. We're almost done with the questions unless any others have any last minute ones. So if a member of a fire department is off duty and called in for an emergency, which happens often that off-duty firefighters are utilized to assist in larger incidents, would they be covered if they were in an accident while responding back to work?
So there's actually a case, I don't know the quote of it, but no, they would not be, because they are traveling from their home, which is a non-work obligation, to another. Whoever has that question, if they want the specific case, there was one where the individual was in charge of the roads and snow plowing and getting them iced, and he had done phone calls at home. And then when he was leaving his house to go work with everybody, he fell down, he slipped on some ice and fell and injured his back. And it was concluded that he was not injured in the performance of his duties, because just because he had made the phone calls at home did not transfer that entire time as a work performance.
I believe the name of that case is FANT, F-A-N-T.
Yeah.
I don't remember what board it was, though.
Okay, and this one is a follow-up to the elected official question. The comment is no. The elected official does not want to continue to contribute because maybe it will impact Social Security.
I don't think it matters whether or not it would impact them if they can't decide not to contribute.
Okay, and then the final question of the day. As a former city councilor and retired city clerk, I believe the local boards should be required to advise elected officials of their eligibility to join the local retirement system. Our own administrator does, as PERAC has suggested, notify our new elected officials, but I do believe it should be required. So more of a comment than a question.
Okay. Yeah, and we understand that, and we do agree that it's helpful to let them know of this, because if you're just entering Chapter 232 for the first time, like I did a little over a year and a half ago, it's very confusing, and there's a lot of information there. So we think it's very helpful for the boards to notify their members. And I think, as I mentioned earlier in my presentation, we did have a board send us forms that they created for newly elected officials to fill out, where one form was yes, I want membership, and one form was no, I do not. So we think that's great, and it should be best practice to notify newly elected officials.
Okay, and I lied. Another question came in. Do you expect that when working at home, ADR cases do come in, that PERAC will need to take a second look at how they apply in the performance of duty standard?
It's such a fact-specific, question that I don't know if it'll be different, but you can be sure that we will look at them with a fine-tooth comb, as the board should, because the board see them first.
Yeah, I don't think I think we're going to take what the standard is and then see how the facts fit in with the standard. We can't change what the standard is, even though it's very harsh. It is what it is. It's been established by the court. So we work with what the standard is, and then, like Ken said, how the facts fit it.
Okay, and well, let me check. All right. For elected officials, if they indicate yes, but don't actually file forms within 90 days, do they get membership?
No, they have to have to say yes, and they have to file the forms with the board within 90 days. So the form we were talking about that we saw a retirement board submit said that it's only effective if you then file forms within the 90 days. So if you are going to create your forms, it's really important to put that on there, because just by clicking yes, that does not mean that you are complete with your membership requirements.
Why is there no penalty or cost for members who apply for AD and their recollection changes based upon how the case is going? Just seems like a waste of resources and time.
I mean, I would agree with you. It was 10 years later, and you would think his memory was best on the day the injury happened when he filed the paperwork, the injury report. So I would agree with you, and the Contributory Retirement Appeal Board agrees with you. But we'll see where that case goes from here.
And a request, can the board that has that form share it, the one that Felicia is referring to?
I think that if that person wants to contact us, we'd be happy to share that form with them. We'll probably redact it just to, because it's one board made it. We'll probably leave their name out of it, but we'd be happy to share that.
Okay, going once, going twice. I think that was actually officially the last question. Right. I'm going to turn my camera on for a second. Well, thank you everyone for joining us today. We appreciate your time this morning. Thank you, Ken and Felicia, for a great and informative presentation. This presentation was recorded and will be rebroadcast at a later date. And if any of your colleagues would like to view the presentation, it will be available for credit next quarter. So you can watch it again, or if you just feel like seeing Ken and Felicia one more time, you can watch it again if you want. Again, the download, if you haven't downloaded the handout, it is available to download from the handouts tab. You can do it now, or just reach out to me later today and I can email it to you. Thank you again for joining us, and we will see you next time. Enjoy the rest of your day.
All right. Thank you, everyone.
Thank you.
Safe and happy holiday.